Have you noticed how some of the most classic albums from 1991 are suddenly all over the news? Well, it's not because of a reunion tour. See, there's this legal countdown clock that was set decades ago, and it's just about to hit zero. And when it does, it's going to trigger this huge shift in who owns some of the most iconic music from that entire era. It all starts right here, with this one specific year, 1991.
So you got to be asking, right? Why 1991? What is so special about that year? I mean, yeah, it was the dawn of grunge, a golden age for hip-hop, for sure. But this is about more than just nostalgia. There is a powerful legal reason that has artists, their families, and the big record labels laser-focused on this exact moment in time. And the whole thing, believe it or not, boils down to just one number.
And that number is 35. That's it. 35 is the key that unlocks this entire story. Think of it like a countdown clock that was literally built into US law a long, long time ago. And for this absolute golden era of music, that clock is about to go off. Okay, let's just break it down. The math here is really simple. You take a song that came out in 1991, you add 35 years, and boom, you land right in 2026. This isn't some random coincidence. This is the ticking heart of a legal right that was designed from the very beginning to give power back to the creators.
So where did this all come from? Well, you have to go all the way back to the U.S. Copyright Act of 1976. Congress saw this pattern happening over and over again. Young artists, hungry for a break, would sign these deals giving away the rights to their music for next to nothing, long before anyone knew what that music would actually be worth. So they built a kind of safety valve into the law, a second chance to get that ownership back.
And this right here gets to the incredible power of this law. It was specifically created to override those old ironclad contracts. You know the ones, the deals where an artist signed away their rights in perpetuity? That means forever. But this law says, nope, not so fast. It was built to give them a way out, even from a forever deal.
The official name for this is copyright termination. And let's be clear, this isn't some tricky loophole or a lawsuit, it is a fundamental right. It gives creators or their families they've passed on the power to just end that old agreement and take back control of their work once that 35-year clock runs out.
So what's the actual prize here? When an artist reclaims their rights, what are they really getting? Well, it's not just one thing. See, to really get what's at stake, you have to understand that every single song has two completely separate copyrights.
Okay, on one side, you've got the publishing. Think of this as the song itself, the notes on the page, the lyrics, the melody. For most songwriters, this is almost always reclaimable. But then, on the other side, you've got the masters. This is the copyright for the specific sound recording of that song. Getting the masters back, that's a whole lot trickier. And it all comes down to some very specific words in the original contract.
And that brings us to the single biggest roadblock, the one legal phrase that can stop a claim for the master recording dead in its tracks. It's an idea that labels and artists have been fighting over in court for years. And that obstacle is called work made for hire. Basically, if a record deal back in the day called the recordings a work made for hire, it means the record label is legally considered the author from day one. And think about it. If the label is the author, then the artist can't terminate the deal because, in the eyes of the law, they never actually owned the master in the first place.
But, and this is a huge but, here's the reality check. Just because a contract said work for hire doesn't make it true. First off, songwriting itself is pretty much never considered a work for hire. And for the master recordings, courts are now looking way closer at these old contracts. They're looking past the legal jargon and asking, who really had creative control here? That shift is prying the door open for a lot of artists to challenge that WFH label.
All right, so who are the actual players in this game? Who gets to file for this copyright termination? Well, it's not just the artists who were in the studio all those years ago.
Obviously, the original creator can file. But what if they've passed away? Well, that right doesn't just vanish. It actually passes down to their family in a really specific order. First to a surviving spouse, then to their children, and even down to their grandchildren. Now, here's a crucial detail. A majority of the heirs have to agree to file. This makes termination an incredibly powerful tool for a family's legacy, but it also means everyone's got to be on the same page. Okay, so we've covered the what, the why, and the who. But how does this whole thing actually happen? I know the legal side can seem a little intimidating, but if you break it down, it's a pretty clear playbook.
This timeline is absolutely critical. The law is very specific. You have to file your notice in a window that's between 2 and 10 years before that 35-year mark hits. So for all those works from 1991, that window is wide open right now. Once you file that notice and the 35-year anniversary finally arrives, the rights they come back. They revert to you automatically.
So the process really comes down to these 5 steps. But honestly, the most interesting part is what happens after step 5, when you've reclaimed control. This is where the real strategy kicks in. You could just use the notice as leverage to go back and get a much, much better deal with your current publisher. Or you could take the rights back completely and shop them to a new company for a fresh start. Or you could go fully independent, control everything, collect all the royalties, and pitch your own music for movies and TV. It's about turning this legal right into a real business opportunity. And let's be absolutely crystal clear about maybe the most empowering part of this whole thing. You are not asking for permission. This is a legal notice, not a request. The publisher or the label doesn't get a vote. They don't get to say no. You are exercising a right that was granted to you by law, period. So, after all that, what's the big takeaway? If you're a creator from that era, or you're the family of one, what are the immediate first steps you should be thinking about right now? Here's a quick checklist to get you started. First, just identify the songs from around 1991. Then, figure out who the actual credited songwriters were. Dig up those old contracts and check that language. See how the rights were handled. Calculate that 35-year window for every song. And finally, get ready to file. But a quick word of caution here. While this is your right, it can get complicated. It's always a smart move to work with a music lawyer who knows the stuff inside and out. For decades, so many creators have felt locked out of the incredible value they created. But because of a law that was written a long time ago, a window has finally opened. That 35-year clock that started ticking way back in 1991 is now in its final minutes. So the only question left is, are you ready to reclaim your legacy?